literally from county to county to county. So we've got Collin County, Hayes County, one in McLennan County, one in Belton County, one in Kaufman County.
This isn't one mistake, it's a pattern. County to county, case to case, theft after theft. She's not confused or unlucky. She's been convicted, sentenced, and kept going. Now the judge sees the full picture. No excuses today. Guilt isn't the question, patience is. And the court may be done being lenient.
Good morning. Are you Contasia Richmond?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Richmond, in cause number 24, DCCR 2306, you're charged with the state jail felony offense of theft with previous theft convictions from September 9th of 2024. The indictment alleges you were previously convicted of theft June 21st of 2019. And then after that was final, you were convicted of theft in 2 cases on the same date, March 21st of 2024 in Bell County, and then again April 10th of 2024 in McLennan County, Texas, and May 31st of 2024 in Collin County, Texas. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
And are those prior convictions true?
Yes, ma'am.
What are the outcome of those last few, 2024 cases?
Judge, I've got the one with 2023 where she inherited Hayes County. Is that the one? I believe that.
I don't even have a 2023 Hayes County in here. I've got two in Bell County, one in McLennan, and one in Collin.
Collin, we got 200 days in county jail.
Okay.
And Bell County. Bell County was 9 months.
What about McLennan County?
I believe most of these were punished as a misdemeanor, 1244. Yeah.
Well, you've got one, the Bell County's out of a district court,
Yes, ma'am.
and the Collin County's out of a district court, which they could have pled them down, but those are both.
This is a state jail. The Bell County was the one in 2024. It's 9 months state jail. And the Collin County was, like you said. I know. The Collin County was a 1244 to be specific, Judge.
Okay. Let me look at something. I don't think I like it. So there's a case from 2017 here out of this court for a 2-year term in prison. What was that for?
No, I had 2 years probation, and then when I went to jail, I had got some jail time with a 1224. I don't know how much it was.
So what I'm looking at here, which is even more than what's included on that indictment, shows a 2017 conviction for theft here in Jefferson County, a 2023 in Collin County, a 2023 later that year in San Marcos,
Hayes County.
I was
Hayes
in jail
County.
that whole time.
I don't care if you're in jail. I care that you're continuing to steal, and that I'm not sure that this deal that you've made is sufficient for what I think, for what you've been doing. So we're not talking about a long time ago. We're talking about the last 2 years.
That's the moment the room shifts. The judge isn't limited to what's charged, she's looking at the pattern. Multiple thefts, multiple counties, stacked back to back. This isn't history. This is recent behavior, and it tells the court everything it needs to know.
So going from literally from county to county to county. So we've got Collin County, Hayes County, then we're into 2024 where there's 3 convictions, one in McLennan County, one in Belton County, one in Kaufman County. And we're back here with an offense date So the offense date here was 9/9, which is actually of 24?
Yes, ma'am.
Okay. So at least that one was before the Kaufman County. So you went from here and then you traveled to Kaufman County within 3 days, got another case there. Or at least you had it before and that was the conviction date. Yeah, nope. I will keep the paperwork. Y'all can go visit. I don't think 12 months is appropriate somewhere. So there's got to be a little more than that, in my opinion. Otherwise, obviously, jail time has not been sufficient to deter.
Listen carefully, jail didn't work. Probation didn't work. Short sentences didn't work. The judge says it plainly, deterrence failed. When punishment doesn't change behavior, the court has one option left. Increase the consequence until the pattern stops.
Ms. Richmond, from going county to county and still in places. So y'all take another look at it. I won't delete it. So if y'all come up with something, I can make that adjustment. If not, if you need some time, I'll reset it and then y'all can talk.
Yes, ma'am.
Okay. And we're back on the record. Cause number 24, DCCR 2306. Mr. Haka.
Your Honor, the state agreed to offer 18 months in this case.
And is that an agreement that you've talked to your client about?
We have discussed that, Judge. Ms. Richmond is willing to take the 18 months, yes.
Ms. Richmond, with everyone's permission, I can make that adjustment on this paperwork. I want to make sure it is your understanding that you are now agreeing that I sentenced you to 18 months in your case. Is that correct?
Yes, ma'am.
And you understand if I follow that agreement that you'll be waiving or giving up any right to appeal. You can't change your mind later and say she gave me 18 months instead of 12. You are now agreeing to that 18 months, correct?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Richmond is not competent.
No, Your Honor.
All right, I'm going to find, Ms. Richmond, that you entered your plea of guilty and true, freely, and voluntary. Well, I'm not even sure. Let me go back just to make sure. I do want to go back to that indictment. Are all of those prior convictions for theft true?
Yes, ma'am.
And are you pleading true because those are actual convictions that you received?
Yes, ma'am.
All right, then I am going to find, again, sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. A firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff. All right, let's get Brandon Bell, please.
18 months isn't about revenge, it's about reality. The judge weighed the choices, the record, and the repeated chances already given. This sentence wasn't forced, it was earned. So here's the question. Was the judge right to draw the line now, or did the defendant burn her final opportunity long ago? Comment below, hit like, and subscribe for more real courtroom breakdowns.
Walked into that courtroom like she had a plan, like she always had a plan. And why wouldn't she? She had done this before, more times than most people cycle through jobs or relationships. She knew the rhythm of arraignments, the cadence of guilty pleas, the arithmetic of county jail versus state jail time. She had learned the system the way some people learn a foreign language, not in a classroom, but out of survival necessity, and, if we're being honest, something that had long stopped feeling like a choice. But this morning was different. This morning, the judge had already done her homework. And the moment Judge Raquel West pulled up that record, the full record, not just the charges neatly packaged into today's indictment, the entire calculus of the room changed. Because what she saw wasn't just a single theft. It wasn't even a string of thefts. What she saw was a map, county to county, conviction to conviction, year after year, a pattern so consistent it almost looked like a career. Here's the thing nobody in that courtroom said out loud, but everyone was thinking. At what point does the system stop trying to correct behavior and start simply protecting everyone else from it? We've all made repeated mistakes. We've all had moments where we knew something wasn't working, and we did it anyway. The difference between most of us and what happens in this courtroom today isn't intelligence. It isn't morality, exactly. It's something more complicated than that. Something about the gap between knowing consequences and actually feeling them land. Something about what happens when the consequences keep coming too late, too soft, or just not quite enough to shift the direction of a life already in motion. Contasia Richmond had been convicted before this case, multiple times, and every single time there had been an outcome, a sentence, a number of days or months attached to a crime. And every single time, she had kept going. That detail right there is the one that makes this case more than just a courtroom proceeding. It turns it into a question we don't have a clean answer to. What do you do with someone who has already proven that the current consequences don't work? If that question doesn't have an easy answer for you, stay with me, because by the time Judge West finishes speaking today, you are going to understand exactly why this case matters beyond the courtroom walls, and why the line she drew is one we all need to think about. Let's start at the beginning. Not the beginning of this case. The beginning of the record. The first time Contasia Richmond was convicted of theft in Jefferson County was 2017. She was young. The conviction came with a 2-year term, though her attorney would later clarify this was probation, with some jail time added along the way. In the world of criminal justice, that's actually considered a relatively measured response for a first serious encounter with the system. The philosophy built into that kind of sentence is hopeful. It says, we believe you can change. We believe accountability without total incarceration gives you the chance to course correct. We believe in the possibility of you. That belief, that hope, is not naive. It comes from decades of criminological research showing that for most first-time or even second-time offenders, community supervision and shorter sentences actually outperform lengthy incarceration in terms of reducing recidivism. The philosophy is sound. The data generally supports it. But there's a threshold. There's a point at which the data runs out and the pattern takes over. For Contasia Richmond, that threshold would not be reached in 2017, or 2019, or even 2023. It would take the courts until 2024, across 5 separate counties, before anyone would finally draw a hard line. And that timeline, that specific, traceable arc from first conviction to this courtroom, is what makes what Judge Raquel West does today so significant. She wasn't reacting to a single crime. She was responding to a record that had quietly been compiling itself across the entire state of Texas. By 2023, the pace had picked up. There were 2 cases out of Collin County and 1 from San Marcos and Hays County. By 2024, the convictions started arriving like clockwork. Bell County in March, McLennan County in April, Collin County again in May. 3 separate convictions in a span of less than 3 months. And then, within days of one of those cases, another offense, the one that would eventually land her in front of Judge West on this particular morning. Think about that timeline for just a second. 3 months, 3 counties, 3 convictions, and in between those convictions, still committing the act that generated them. That's not someone who doesn't understand what they're doing is illegal. That's not someone confused by the system. That is someone for whom the system, up to this point, has simply not created sufficient reason to stop. And that distinction, the difference between not understanding consequences and not caring about them, that's the distinction Judge West is going to wrestle with in real time this morning. When Contasia Richmond steps up before the court, she is composed. Her attorney has already agreed to waive the formal reading of the indictment. This is standard practice. It saves time. It shows cooperation. It signals to the court that the defense isn't here to fight the facts. And the facts in this case are not in dispute. The judge runs through the charges calmly, methodically. State jail felony offense of theft with previous theft convictions. Offense date September 9th, 2024. Prior convictions laid out one by one. 2019. Then the 2024 cases in Bell County, McLennan County, Collin County. She asks Miss Richmond directly, how do you plead? Guilty. Are you pleading guilty freely and voluntarily? Yes, ma'am. Are you pleading guilty because you did what they've charged you with? Yes, ma'am. There's a particular quality to those answers. They're not defiant. They're not broken. They're just matter of fact. Like someone who has been through this particular conversation enough times that the words come automatically, like a script she knows by heart, because she does. Now here's where the morning begins to pivot. The judge starts asking about outcomes. What did the prior cases result in? The attorney begins pulling up information. Collin County, 200 days in county jail. Bell County, 9 months. McLennan County, 12 months. And as each number gets added to the mental ledger, something in the judge's posture shifts, because she's already looking at something the defense attorney may not have fully accounted for. Wait, I need to back up for a second because this detail changes everything. While the attorneys are discussing the 2024 cases, Judge West is looking at a broader picture in the database in front of her, and she finds something that wasn't specifically highlighted in the indictment she's working from. A 2017 conviction out of Jefferson County, a case from this very court, a 2-year prison term, or as the defense corrects it, a 2-year probation with subsequent jail time, and then additional cases from 2023 in both Collin County and San Marcos. The judge says it plainly. I don't think I like it. 5 words. No theatrics. No dramatic pause. Just a judge looking at a record that tells a story the plea deal sitting in front of her doesn't quite address. And in that moment, the carefully arranged negotiation between prosecution and defense, the 12-month sentence they had agreed upon, suddenly feels inadequate to the person who actually has to sign the paperwork. She says it directly, going literally from county to county to county. Collin County, Hays County, 3 convictions in 2024, 1 in McLennan, 1 in Bell, 1 in Kaufman, and the offense date on this current case, September 9th, which placed it before the Kaufman County conviction, meaning Richmond had picked up a new case in Kaufman County within 3 days of the conduct that led to this morning's proceeding. 3 days. That's not a detail buried in the file. That's a detail that tells you everything you need to know about the severity of the pattern. 3 days between an offense in Jefferson County and a separate case in Kaufman County. The geography of the theft followed a logic of its own, not proximity, but opportunity. Wherever opportunity existed, the behavior followed. The judge pauses the proceeding, tells the attorneys to go back and look at it again, tells them 12 months isn't appropriate, tells them, with the calm certainty of someone who has watched this particular story play out too many times, that jail time clearly hasn't been sufficient to deter this from happening. Listen to what she's really saying in that moment. She isn't angry. She isn't performing for anyone in the gallery. She's making a clinical observation about a system that has repeatedly offered a consequence and watched that consequence fail to produce the intended result. And she is refusing, in her courtroom on this morning, to participate in offering that same consequence one more time. The attorneys step aside. They confer. And when they come back to the record, the number has changed. 18 months. That's the new agreement. Not 12. Not the number the defense had walked in with, expecting the judge to simply follow the deal as arranged. 18 months in state jail prison. The judge confirms it directly with Richmond herself. You understand you are now agreeing that I sentence you to 18 months? Yes, ma'am. You understand you're waiving your right to appeal? Yes, ma'am. And here is what is remarkable about that exchange. There's no outburst, no protest, no loyally maneuvering to push back, because somewhere in the logic of this moment, even Contasia Richmond seemed to understand that the math has finally caught up with the behavior, that the judge looking at that record and saying, I don't think 12 months is appropriate, was not being unreasonable, was not being vindictive, was simply doing exactly what a judge is supposed to do, weigh the totality of what she sees in front of her and respond accordingly. Judge West finds Richmond guilty, states the sentence, 18 months in the state jail prison, with credit for time already served in custody. She hands over the trial court certification, confirming the agreement and the waiver of appeal. She provides a written admonishment about firearm ineligibility. And then she says something that carries more weight in its simplicity than any speech could. Good luck to you, ma'am. Good luck. Not because she expects it to change anything, not as a pleasantry, but because in a particular ecosystem of a courtroom, where outcomes are measured in months and the human cost of decisions lands somewhere far beyond the four walls of the chamber, what else is there to say? She did her job. She drew the line where the record told her to draw it. And now the rest is up to whatever forces, inside and outside a state jail facility, might finally accomplish what county jail and probation and sentence after sentence could not. Now, here's what I keep coming back to when I think about this case. The justice system is built on a theory. The theory is that consequences shape behavior, that awareness of punishment or experience of it creates a rational calculation that causes people to change course. It's a deeply intuitive theory. It matches how most of us move through the world. We touch a hot stove once. We don't do it again. The pain is the lesson. The lesson is the prevention. But human behavior is not a stove. And some patterns run so deep, are so intertwined with circumstance and psychology and access and desperation and habit, that the stove metaphor completely breaks down. What happens when the heat doesn't register the way it's supposed to? What happens when months in county jail become, effectively, just another part of the cycle rather than a circuit breaker within it? The judge saw that. She named it without editorializing. Jail time has not been sufficient to deter. That sentence, those 7 words, contain within them a quiet indictment not just of Contasia Richmond's choices, but of every prior sentence that came before this morning. Every judge who accepted a deal. Every agreement that traded time for peace. Every moment the system chose the path of least resistance and told itself that 12 months would be enough. It wasn't enough. It kept not being enough. And now here we are, at 18 months, asking whether this number is finally the one that changes something. The honest answer is, we don't know. That's the part that doesn't get said in the courtroom, because courts aren't in the business of uncertainty. They render verdicts. They impose sentences. They move to the next case. But the question of whether any particular sentence will transform behavior is a question that belongs to the 18 months that follow, to whatever programming is or isn't available inside a state jail facility, to the circumstances Richmond returns to when she walks back out, to whatever internal shifts may or may not have begun to accumulate across years of convictions and consequences. What Judge West did was simple in execution and genuinely difficult in judgment. She refused to be complicit in a pattern she could see clearly. She used the authority of her position to say, with every action available to her within the law, that this is where the line is drawn, not out of cruelty, not out of indifference to the human being standing in front of her, but out of a recognition that the alternative, accepting the 12-month deal, moving on, watching the same record grow one more line longer, would be a different kind of failure. And that's what a courtroom at its best actually is. Not a place of revenge, not a performance of power, but a place where someone has the responsibility to look at the full picture, all the months, all the counties, all the agreements and sentences, and fresh starts that somehow didn't take, and respond to what's actually there. Here's what I can't stop thinking about, though. At what point in that sequence of events was there a moment where something different could have happened? Not in the courtroom. Before that, was it 2017, when a 2-year probation was handed down, and perhaps the support structures needed to make that probation meaningful simply weren't there? Was it 2023, when 2 separate cases in the same year somehow didn't trigger a harder reckoning? Was it March 2024 or April or May, during those 3-month stretch of consecutive convictions, when maybe a different kind of intervention might have interrupted the momentum of a pattern that had by then become almost self-sustaining? We don't know. We can't go back and find that specific second where everything could have changed. And that's the part that haunts me about cases like this one. Not the outcome, which is legally defensible and arguably overdue, but the distance between the first mistake and this courtroom, the years of chances that were given and taken, and somehow never quite became the turning point anyone hoped for. The sentence is 18 months. The gavel has come down. The paperwork has been signed. But the questions don't close with the courtroom door. So I want to ask you something directly. When you look at a record like this, county after county, year after year, what do you feel? Is it frustration? Exhaustion with a system that kept offering chances that weren't taken? Compassion for someone whose life clearly contains a depth of context and circumstance we can only partially see from a transcript? Some complicated mixture of all of it? Because I think that mixture, that inability to feel just one clean thing about a case like this, is actually the most honest response. And I think it tells us something important about why these cases don't resolve neatly even when the verdict is handed down. Leave your thoughts in the comments, not about whether she deserved it. That's too simple a question. But about where you think the real failure happened. Was it the system that kept accepting soft deals? Was it the circumstances that kept producing the behavior? Is there a point on this timeline where you would have drawn the line differently? I'm genuinely asking, because the answer you give says something about what you believe justice is actually for. If this case made you think, really think, hit like. It costs nothing, and it tells me these are the kinds of stories worth spending time on. Subscribe if you want to keep asking hard questions about the moments when ordinary systems meet extraordinary patterns, because there are more stories like this one. Stories that don't end clean. Stories that stay with you after the tab is closed. Somewhere tonight, someone is making a calculation about risk, about consequence, about whether the cost of what they're considering is really as high as the system says it is. And the choice they make in that moment matters more than any verdict handed down after fact. That's the thing about patterns. They don't start in courtrooms. They start in much quieter moments than this.